After most first-time DUI convictions in California, the court sentences you to informal probation, sometimes called summary probation, instead of active jail time. It typically runs 3 to 5 years. The conditions are specific. Stay out of trouble, complete a licensed DUI program, pay all fines and fees, never refuse a future chemical test, and never drive with any measurable amount of alcohol in your system. Breaking even one of those conditions can send you back to court. The violations that come up most often are a new DUI arrest while still on probation, missing or failing DUI school sessions, failing to pay court-ordered fines or restitution, missing a probation-related court date, and picking up any new criminal charge, even one unrelated to alcohol. Worth knowing, under Vehicle Code 23154, driving with a blood alcohol level of just 0.01% or higher while on DUI probation is itself a separate offense, on top of any new DUI charge the prosecutor may also file. A probation violation hearing is not the same as a criminal trial. There is no jury. The judge alone decides whether you broke a condition. The standard of proof is lower than at trial. The prosecutor only needs to show it is more likely than not that the violation occurred. That is called preponderance of the evidence. The judge then decides the consequences on the spot, which is why walking in without a clear plan or documentation can be a serious mistake. The range of outcomes is wide. On the lenient end, the judge can give you a warning and reinstate the original probation terms. In the middle, the judge can add new conditions like a scram bracelet, an extended DUI program, or more community service. On the serious end, the judge can revoke probation entirely and impose the suspended jail sentence that was hanging over your case from day one. On a first DUI, that suspended sentence can be up to 6 months in county jail. The outcome depends on what the violation was, your history, and what your attorney presents. If your violation is technical rather than a new arrest, there is often something you can do before the hearing date. If you missed DUI school, get re-enrolled immediately and get documentation. If fines are unpaid, start paying what you can and keep records of every payment. Judges pay attention when a defendant takes responsibility and corrects the problem before the hearing. Bringing that proof with you to court can matter a great deal in how the judge treats you. When the violation is a new DUI arrest, you are fighting 2 battles at once. The probation violation hearing can move faster than the new criminal case, so a judge could revoke your probation and order you to serve time before the new case is even resolved. On top of that, a new arrest can trigger a separate DMV administrative suspension, even if you are already driving on a restricted license. The court side and the DMV side operate independently of each other, and both can move quickly. Whether you are dealing with a missed class, unpaid fines, or a brand new arrest while on probation, the steps you take in the next few days genuinely matter. I'm Joel Brand, a California DUI lawyer. This is general information, not legal advice. If you want a free written case analysis, it is at DUI.guru.